Well, the first kind of premise I have is there's two themes today, and one is that things are not really getting any better on the lender side. There have been years of accounts and admissions and all kinds of acts and omissions of banks, but there doesn't seem to be a real cure to that. Right now we have to say the same things. And there seems to be a bit of apathy in the media for these same issues. So I would say that the first theme really is things are not getting better, they're kind of getting worse. And then the folks themselves that are at issue here are not, this is not a zealous lobby of foreclosure attorneys who are saying the banks are bad. So I read a list of the banks who themselves have been signatory to consent judgment. So they've admitted themselves that there's been misconduct with regard to mortgages and servicing of loans. So Ally, GMAC, Bank of America, Citi, Chase, Wells Fargo, PNC, SunTrust, US Bank, HSBC, Goldman Sachs, Litton, Aurora, Everbank, One West, Sovereign Bank, Select Portfolio, and Bachman. All these folks have said, have admitted to cultures of fraud, to cultures of misconduct in their writing of mortgages and servicing of mortgages. So this is not something that the defendants are saying or the homeowners are saying. It's something that the people themselves have said, that the banks themselves who have caused these things have admitted. That being the kind of the context where we're starting from. So let's look at before the foreclosure litigation became a very large impact upon the courts and the country. So pre-foreclosure boom back in prior to 2006, there was a pre-world of how these things went. And the first issue you had was the indicia of a bank's representations. Nobody ever doubted a bank coming into court. And I laughed that I did this before foreclosure defense became cool. I went in there when banks were saying, of course we, have a default here, and there was never any kind of doubt or scrutiny to that. And at that point in time, you really hadn't seen a time where foreclosure defenses had matured. It was whether you paid or didn't pay. And the whole mortgage-backed securities and the assimilation of these loans together hadn't really been a big issue. So the other issue back then was there was not a strain upon the court's docket. Foreclosure filings were manageable. There was no need to make special account for them, and it was a case like any other. There was no other issue with regard to that. Well, at that point in time, banks prevailed a large majority of the time. About 99% of the time, they prevailed. And at that point, you also had a culture of lending that was conservative. And I say that by giving an example. Say you had someone that goes to a bank where they've done business for 10, 20 years. They apply for a mortgage, and the mortgage is reviewed and underwritten. And they get a response, say Bob, we'd like to give you a loan, but we can't give you a $300,000 loan. I can give you loans of $150,000, but I can't give you a $300,000 loan. That occurred back then. You had banks that would actually evaluate loans and say no. Well, that tide turned with individual by Angelo Mazzillo and Countrywide, and some other banks that also kind of jumped on. So at that point in time, you had banks that were making appropriate loans, underwriting sufficiently, and giving loans where they were warranted. At that point in time, you had what I would call nominal mortgage fraud. There was not a scenario where it was pervasive and cultural. Now, from that point, there was a change, and the turning tide occurred after the 2006 timeframe, where loans were plentiful and easy to get, and the comments about getting a loan were you fog a mirror to get a loan. It wasn't a matter of having to apply with the required documents. So then you have these aggressive underwriting practices, aggressive lending practices. And the number one example was, of course, Countrywide. You had their underwriters being either incentivized by being paid off to pass on bad loans, or they were being threatened. They were being, their tires were being slashed, they were being threatened with violence if they didn't pass on these loans they should have been otherwise denied. So the best practices of underwriting had changed at that point in time, and that was a culture that went to other lenders too. It wasn't just Countrywide. Other lenders assumed that same kind of mindset and would ask very vague questions and suggest answers to folks, and that resulted in a whole lot of loans that should not have been written. So at that point, these aggressive underwriting practices led to the deterioration of whatever standards were out there. So one of the examples you have comes from these call scripts from mortgage loan reps, and one of them particularly was from Countrywide. And they would call and suggest to somebody a results-based answer. Well, for this loan, you need to make $48,000 a year. You do make $48,000 a year, don't you? And the course, unwitting borrowers would fall into that trap and say, sure, yeah, I do. So you had scenarios where the loan reps would pass through loans that should not have ever been underwritten, should not have ever been resulting in mortgages, but it occurred. And we had a scenario that was actually kind of scary because we saw it after the fact. It was a loan where somebody had applied for a WAMU loan, and the gentleman was a Pinellas County sheriff. And he applied and he had his accurate income on the application. And then in discovery we requested what was actually provided to the lender. And someone somewhere doctored the application and wrote down that he made $90,000 a year as a Pinellas County deputy. So, and it was a shock to him, a shock to us. But that was going on. You had loan reps that were forcing through loans they should not have been given. And you also had problems with loan reps who were allowed to disregard guidelines. You had guidelines for salaries, for appraisals, for value of houses. And they were permitted to go ahead and deviate from those guidelines when they offered loans. And that was a frequent occurrence. So at this point, you have courts that are becoming a little more cynical of those representations. So, trust me, we own a loan. Trust me, we have standing. And then the Pandora's box opened with other types of issues like robo-signing, contrived documents, backdating documents, and other practices that were clearly impermissible under law. So you have scenarios where attorneys at firms doing foreclosure work were signing 1,000 affidavits a day. They were, you had these mass signing by paralegals and by assistants that were notarizing documents, 500 at a time, 1,000 at a time. And that resulted, of course, in some questionable practices and some fraud on the part of those folks. Many of them now have been taken into account for by either the state of Florida, the bars, or other courts in the country. And some other examples that have come out recently had to do with some large banks, one big Bank of America. And there was some affidavits filed in a case in New York, maybe about 6 months ago, where a number of employees had attested to the fact they were incentivized to forward cases to foreclosure, even though there was not a basis to do that. There had been a pending modification request, there had been some other loss mitigation option that was being utilized. And unfortunately, they were being paid $500 a file to push them through to foreclosure counsel. That's those same affidavits in that same case also talked about what they call the denial blitzes. And in context of having loss mitigation options, rewrites or modifications, they were allowed to and were told to, in these denial blitzes, deny up to 1,000 files at a time for no good purpose at all. And of course, those would get forwarded to foreclosure counsel and result in foreclosures. The final issue that began this whole challenge of foreclosure matters was the underwriting guideline that we're not going to help any consumers unless they're in default. And bank reps were candid about telling people will call for help and they were current, and they would say, I'm going to have problems in the next few months, I'm going to need some assistance, what can you do to help me out? Universally among the banks, the response was, we can't help you when you're current. You need to default in order to get help. People would default to get help, and then no help with whatever we had. So there were some statements that were questionably made to borrowers that inducing them to default with the idea that they would get assistance and then never get the assistance thereafter. A really recent development occurred this past week, actually, in a case in New Jersey, a federal case. And in that case, there was a Wells Fargo attorney manual that was disseminated. I don't know, it was filed before by the attorney for the borrowers. And that manual had examples and formalized methods of how to do to backdate documents, to have attorneys sign endorsements or launches, and to otherwise create documents that didn't exist at the time of filing the lawsuit. And it's been really hot in the press the past few weeks, but I think 2 weeks ago was the day that it finally hit. But it's available online, you can download it pretty easily. And it's shocking what Wells Fargo was telling their attorneys to do in the terms of creating documents that don't exist, backdating things, and contriving notary signatures that didn't exist when they should have been executed. The next issue, which is very, very a part of this whole litigation issue, would be the mass of foreclosure filings. At its worst in Florida, and I know the numbers right now are not the same, but 3 out of 5 mortgages were underwater, so a very, very large number. And at one of the heights of time, there were 700,000 active foreclosures. Now, I know currently right now the numbers are not that bad, but that was the worst that it got in Florida. And the result was there were more new file being dispositions. So they weren't able to go ahead and resolve cases at the same time of getting barraged by new filings. Dockets, there were court dockets where trial judges had upwards of 3,000 to 5,000 cases, making it impossible to manage dockets. And that resulted in other cases, non-foreclosure cases, being impacted. For example, if you had so many foreclosure cases, you couldn't get hearing time in other cases. So the whole process just kind of brought gridlock in the system, to the court system, and to the flow of litigation forward. So as a result, the state and the courts undertook some actions in which to try to resolve this issue. And the first caveat, and it's, I would say, universal to Pinellas County. Pinellas County has been always a shining star of due process. I don't say that because there are two judges here, but I say that because that's been the case in Pinellas County. Other places in the state of Florida where we practice, it's not this good. And there are scenarios where things are happening in foreclosure cases that don't happen in other cases. For example, other counties and courts you have, and I would also further say there's never been a rocket docket in Pinellas County. There have been rocket dockets in other counties. I'm talking about people getting a scant few minutes to go ahead and defend themselves, and a process where it was all about really numbers. Now, there have been, in other circuits also, there's been a reliance upon retired judges and senior judges to resolve the entire case. And that's, again, Pinellas County is the exception to the flow of questionable, foreclosure management practices. But other counties that are outside of Pinellas have had scenarios where retired judges or senior judges are resolving cases in which they really are not quite there in law. I had one example in another county where we had filed a motion, and there was a new rule of civil procedure, and the judge hadn't heard of that new rule of procedure. And we were talking about the fact that it was a verification issue, and it was a new rule by the Supreme Court, and he didn't know about that rule at all, so he went ahead and said, "I want to go ahead and punt to the judge was assigned to." So you have admissions like that where they aren't up to date on what's going on, even the rules themselves. So again, outside Pinellas County. So the next issue that we had was the Supreme Court issuing a rule that magistrates could be used to resolve foreclosure cases. Now, there is a provision where people can opt out and object to having a magistrate resolve a foreclosure case, but the next step was to go ahead and utilize more hands on deck to assist with the backlog issue. So that's one of the new procedures that were instituted by the Supreme Court of somewhat recent time frame. I think it's been about a year ago. Now, the next issue, which actually predated that, was a requirement by the Supreme Court that a lender filing a foreclosure action must do it under oath with a sworn verification. That had been a problem because folks were filing lawsuits as banks who were either servicing or in some other representative capacity, but they were not the actual owner of the loan. And their ability to enforce it was in question. So that rule came into play where you need to, under oath, verify and affirm that you are authorized to file this action. And it was a good idea, but at the end of the day, you had a lot of third parties signing off on these, so it was still somewhat unclear that they were how to enforce the documents. Next issue was a rule by the Supreme Court that had to do with mediation. And there was a managed mediation program where cases were automatically put into mediation. Now this mediation was a little bit more short in scope and compressed than a regular mediation. And very rarely did you ever have bank parties attending. It was always a scenario where they were appearing by phone for these mediations. And when you would question them in these mediations, you'd say, "Do you know you're in an actual court mediation?" And not have that attend, they would say, "No, I thought I'm here for a settlement conference or conciliation." So, and then you ask them about the case. Do you know the facts of this case? And of course they would say, "No, I don't. I'm just here to basically do a warm body." So that program occurred, and I think the stats were not real favorable at being greatly successful. It did go ahead and result in some mediation resolutions, but at the end of the day, I think the banks didn't take it seriously enough. So you had a small success rate of those issues. Next issue we go to is the current morass right now. That morass is you have external pressures upon the courts from the legislature. And the legislature has acted a number of ways to address the backlog. And I will say that banking lobby is very, very well funded, very articulate, and very effective. 3 times prior, there have been 3 sessions where they've tried to bring legislation that affected foreclosure issues. 2 times prior, they tried to institute a non-judicial foreclosure bill. And other states besides Florida have this, so California, Georgia has it. And what happens is, upon default, you get a certified letter from your bank. If you don't act upon that certified letter by filing a lawsuit yourself against the bank, your house is set for sale. So it is a automated procedure with a whole lot of opportunities for concern for fraud. And the irony is that in Florida, we're moving towards, there were moves by the bank moving towards less protections. Other states across the country are moving from non-judicial to judicial because of the problems. And they're trying to go ahead and have other safeguards. And yet Florida had a lobby and had a move to go ahead and reduce those protections. So twice prior they tried non-court foreclosures, twice prior it failed. Past session there was a bill that was finally came through on the last day of the session. The House version was picked because there was a possibility of the Senate version losing out. So that bill had some questionable things in there. Things that attorneys that embrace due process would be shocked by. First issue was a retroactive application of the law. We all went to law school, ex post facto, we have to have the law first, and then the application. This bill sought to have retroactive application of the statute. You can be litigating your case for 6 months, a year, doing fine. All of a sudden the law changes, and whatever headway you made in that case is all lost. And you were now under a different standard before the case, a different standard from that which the case was filed under. So there was that first issue of trying to retroactively apply this law. The second problem was, probably the most galling of all, was the defendants bearing the burden of proof. And in lobbying against this, we use plenty of examples about, imagine a Lucy of a murder defendant having to prove I didn't commit murder. It's an affront to our system of justice and due process. Yet the bill included a provision that sought to have the defendants have to make a burden of proof against there being a legitimate foreclosure, as opposed to having that burden line with the plaintiffs. And the final part of that statute that was concerning was a finality foreclosure protection. So under 1.540 now we can go back and vacate judgments. They wanted to go ahead and preclude that from ever happening. That once a foreclosure was final, you could never challenge it. You were locked in. So despite having occurrences of fraud and misconduct that had been proven, there was a kind of a soft making that occurred where some parts were taken, some parts were not taken. There was one positive provision of that statute changed, and it was reducing the deficiency time frame from 5 years to 1 year. That was the one positive thing taken from that. But at the end of the day, just the overreaching elements that they tried to seek, the bank tried to seek, was very concerning. These are things that, as attorneys, we hold dear, due process, and those kind of things. And it seemed to be very, very problematic in those regards. So, and what happened is this whole bill was one that was submitted by one senator and one House rep. It actually was drafted by the banking lobby. The banking lobby had hired somebody to draft it and, of course, passed it off on them as their act. The irony is the very, very first time it was passed, was brought up, was in a freshman representative's term. So she's a new rep for a matter of months, and all of a sudden she's submitting this revolutionary bill that she claims to have drafted herself. So a lot of banking lobby involvement with regard to House Bill 78 and prior occurrences of legislation regarding foreclosure. So this is the first issue that has tried to stem the tide of the backlog. And it's not been, the backlog still exists. The next issue has been a pressuring of the courts by other forces, by the legislature, by the executive branch, but primarily by the legislature. Apparently there's been some, and I speak from talking to folks in the know, actual people that are involved in this, so I'm not talking off the cuff, but they're receiving pressure from Tallahassee, tying funding to dispositions. Now they don't talk about how they want them to be disposed of, but they want to have dispositions, period. And I know of a meeting occurring, had a hearing in Seminole County a few months back, and the chief judge, who is now doing foreclosure matters, was talking about this meeting he had with all of the chief justice and all of the chief judges of the circuit. And what he said was, the meeting occurred by the chief justice opening up with talking to everybody and saying, gentlemen, and ladies and gentlemen, we're going to be good stewards of the money we've been given, okay? And we need to have more money going forward. So I need you to tell me what you are doing, each chief judge is doing, to what kind of practices they're employing, what kind of programs and policies they're engaging in to resolve the backlog. So each person would go and questions were fired away. Well, what are you doing? What are you doing? What are you doing? And he laughed at it because he was the 18th Circuit. All the things that had been given were already taken, so he's like, his response was, well, we're doing that as well, too. But from what he indicated that meeting was a result of was pressure from some folks in the legislature saying, we need to thin the backlog. And I talked to other folks in other positions, and it said, does anybody evaluate the propriety of that? That's kind of stepping on toes, kind of, balance of power type issues. And apparently the pressure has been so great and so pervasive that the legislature really is acting in an unchecked fashion. So their pressure has been effective in pushing through. So that is the concern that's now, is that they're holding funding almost hostage for dispositions. Dispositions in what way? They really don't address whether we're fully due process or not. They want to have cases closed down. So that's the next issue that kind of become a scenario in the bigger picture. The next issue is the due process considerations. Every one of the examples I'm giving is not in finales. Again, caveat. A circuit that's very close to here had an occurrence where we were getting cases set for trial. We had a case management conference, which were running 3-1 trial date, and we had a trial date set, and we said, well, that's how long we need it. I said, well, we have 4 witnesses. This is a commercial case, a foreclosure nonetheless. We have 4 witnesses we're going to put on, so we're going to be half a day. The judge laughs at me. No, you're not getting half a day. So we have 4 witnesses. No, don't you worry, you're not getting half a day, but you have plenty of time. But then he turns to the court clerk and says, how many cases have a trial that day? Okay. We would have been number 91. So I don't know of any other context in the law where 91 trials are set in one day with the idea that any of them are going to get resolved. So, and the problem was the public records request was made to see if that's endemic upon that circuit or not. 90, 91, 89, 86. So their practice was to go ahead and set up for trial on a certain day, even though there were going to be over 90 trials in one 8-hour day. And a newspaper in that area did a profile on that and asserted those same issues that were being kind of called out. And you have scenarios in another circuit where, north of us, where court staff is calling plaintiff's counsel and saying, hey, I see this case is a Smith case, it's kind of an old one. Why don't you go ahead and file this motion, set it for hearing, and that'll get you guys kind of accelerated along the way. So why don't you go ahead and do that? Without bringing in, defense counsel all those balls. So we raised that issue as well. Said, isn't that ex parte communication, issues? I mean, you're talking about substantive things. It's not scheduling. It's looking at the case law on that. I think that's not, kosher. And their GC from the circuit denied it happened, despite, receiving the calls personally that they think they're happening. So you have scenarios where that's happening. And then you have scenarios in other circuits in the Central Florida area where banks they've blown their response time for any kind of defense at all. They are 20 months past asserting any defense at all. And the court's going to give them leave to amend and say assert defenses as you wish. Same scenario with regard to discovery. They are 24 months over. This is with Bushland's Cabell being filed and was trying to follow up with the whole thing. And courts over there are letting it slide. Okay, you can go ahead and respond. You've not waived your right to object to discovery, assert your objections, and then we'll go forward. And other areas, other circuits too, and these are more in the South Florida area, borrowers are asking for depositions of the bank. Prove you own the loan when you file the suit. Just prove it up, that's all we need. Or being denied. No depositions for you at all. You need discovery, asking for a depo is being wasteful, you don't need that. And that's occurring in that area as well. One of the tricks employed by the plaintiff firms, where they've got to deal with legitimate defenses, legitimate counterclaims against them, is to shrink the time frame down. So on a weekly basis, we get calls to resolve 20 and 30-page motions at 5-minute hearings. I can't argue that motion in 5 minutes, I'm sorry. And of course you have, over and over, you have them doing this again. So hearings for 5 minutes, 15 minutes, 20 minutes. And we try to go with the punches and go to those hearings. And after an hour and not having a resolution, we have to come back again. So we've taken kind of a response that, look, I need more than 5 minutes to argue this. So that's where the plaintiff firms are realizing if they can't beat you on the merits, we can go ahead and silence you for your matters. Another thing that's happening in Again, more in South Florida, and the South Florida counties would be a unilateral trial setting. Okay, trials are set without any kind of involvement of defense counsel, date screening. No, you're just going to go ahead and set trials. And there have been examples where people have tried to continue them because of conflict and other issues, and those courts have just said, sorry, we're not going to do it. We have a backlog, trial on this day, show up or not, it's going to be set. So other circuits in the South Florida area have been notorious for putting on a trial docket, that's that, no, we're not going to move it. And whatever happens, happens. So finally, I get into kind of this, why are people opposing foreclosures? What's the basis for it? Is there a legal basis for it? And the number one problem that I see and we see systematically is a scenario where, and again, let's back up even further, not everyone's going to oppose a foreclosure case. A lot of these things are defaulted and resolved with only one party at issue with the bank. So those folks are going to be, under cover of night, those cases will be resolved, no problem, in favor of the banks. But scenarios where the banks are filing a lawsuit first and then getting their ducks in order later are the concern. And the first big issue is standing to sue. Everyone is asserting that as a defense. And the assertion of standing to sue is not that you can go ahead and file a lawsuit but you don't own a mortgage or not entitled to enforce it. Somewhere in the case later on, get an assignment, get an endorsement, and then say, okay, here you go. The law is quite clear in Florida. Retroactive to the date of filing suit, you must have standing. You must be able to enforce the note and mortgage. You can't go ahead and file suit and get an assignment a month later. And banks are doing that. Banks are filing these actions with questionable standing or non-existent standing. And one of the big problems is they use they travel upon an undated endorsement. And that's the entire basis many times for foreclosing a mortgage. Very often they file a lawsuit with the attached note and mortgage with no endorsement. Okay? And then when they file the original, they file a copy later, it now has an endorsement. So we can't benchmark on the documents alone that they had the right to enforce the note and mortgage at that point in time. You have to go back in time and say, when can you show us and prove up that you were entitled to enforce the note and mortgage? Circa the date of filing, not anytime after. The other issue is where they will have conflicting documents. They have an endorsement in blank and they have an assignment. Well, having two documents clouds the issue a little bit. And if they have an assignment that's filed after the lawsuit's filed, well, we've already got a little bit of proof there that they didn't have it when they filed the suit, so that's a problem. And then looking back at the date of this endorsement, when did that occur? How can we go ahead and benchmark that? And banks are having a very hard time doing that. We get a lot of scenarios where I'll have a bankrupt admit, I've never seen that endorsement before filing a lawsuit. I've never seen any proof that we done it beforehand, and I'll ask them, is there any evidence that exists that proves when that came to you? And the answer is no, typically. Now sometimes they will go ahead and rely upon a screenshot or a log entry in their notes. And that evidence of it in and of itself is so unreliable. You see a screenshot of a computer and it will say, pool closed or name of the pool and a date. But there's nothing in that screenshot itself that tells me that I can verify that on that date, that loan was conveyed to them. So one of the big concerns is that they're walking into court without the authority to enforce a note and mortgage and thinking that they can go ahead and later fix that. And I tell clients all the time that plenty of things in lawsuits you can fix after you file. Standing's not one of them. You got to have your ducks in a row before you file a suit. So that's the first issue. Second issue would be one of conditions to proceed. And the big one everyone talks about in the foreclosure world is the default letter. The default letter. Is the default letter compliant? Is the default letter sent? Is it received? And a recent case came down from the second DCA last week that seems to move that issue a little bit. It's still at a 30-day period of time before it's final. But when you declare default pursuant to the Article 22 of the mortgage, you have to make certain statements, certain references. And the letters that are sent often do not contain those factual scenarios and those factual predicates. So a lot of folks will go ahead and defend on the basis that there was no requisite default letter received. And because of that, it bars foreclosure. That's a very, very big area of defense. The next issue is one of unlawful collection. And this is a kind of an easy factual example. If a person does not own or is entitled to enforcement of a mortgage, any corresponding collection thereafter will become unlawful. And I use the example all the time to say that I go ahead and tell someone that, Mr. Smith, I know your loan, and you pay me your payments to me, Charles Gallagher. I'm going to invoice you every month for your loan. Pay them to me. If it turns out that I don't own that loan, that action right there is 100% unlawful. I mean, how is it not anything other than fraud or an unlawful collection? So, if you have a bank that is trying to enforce a loan they don't own, is not entitled to enforce, that becomes an unlawful cause of action on their part. Another scenario of offenses would be one of different notices you must get in the event of a change of a mortgage servicing. So, oftentimes you'll have, your loan originated with one party and somebody else will service it. And for the change in that servicing, you're entitled to a hello letter, goodbye letter from the two servicers. And very often, those are not being done in the cases. Other issues of collection violations, if people are collecting upon a party directly after having purchased by counsel, or collecting with a harassing tone, or harassing frequency, or saying things they can't bring to bear. For example, if it's almost commonplace to see a collector for a mortgage company telling someone, we're going to take your car, we're going to take money out of your account. And they're not qualifying this is going to be in connection with the execution of a judgment. They're saying we're going to take money from you if you don't pay your mortgage. And the worst example that I can think of for the collection issues resulted from a couple years ago. And banks are using a clause in their mortgage, which is to confirm the property as unoccupied, vacancy exclusion. They're using that to collect loans. So what they're doing is they're sending out people to people's houses and confirming that there's people living there or not. If they're not living there, they can take possession and secure the property. But they're using them for collection purposes. For example, December 10th of, I don't remember what year it was, but December 10th recently, client's outside in his yard with kids. The guy comes up to him and says, your sale's next week. What are you going to do? What? The foreclosure sale's set next week. How are you going to tell your kids are out of their house for Christmas? How can you tell your kids there's no Christmas? How can you tell them that? Of course, the guy panicked and freaks out. What do you mean? What do you mean? Your house is set for foreclosure sale next week. What are you going to do? You need to go ahead and give us a check right now for everything, or you're not having Christmas. God, and this happens after hours on a Friday, ironically. So I get a call after hours, the guy freaking out. Police lock it up. They haven't even responded to our motion to dismiss. They haven't responded to discovery. There's no sale even close. And yet somebody went in there with clearly false statements that intimidated the guy into paying. And so imagine those cases where there's not counsel involved, where the bank reps are, not being challenged with issues. But it's occurring on a pervasive basis. We've had a number of scenarios where people are using the vacancy inspections to collect and to intimidate borrowers and doing things that that are false, that are untrue. So you have other issues as far as counts regarding whenever the loan ownership is changing. If a loan is owned by one party and changed by another party, there's a provision or TILA that you have to get a notice of change of creditor. And you're not doing that. And the final issue of the problems that are happening in the foreclosure issues are the underwriting of loss mitigation. Thankfully, the new HAMP legislation that came into place, the new effective law of January this year, January 10th, is going to help fix that. But when somebody is asking for help and they say, okay, you have to go ahead and apply for a modification, it's the equivalent of putting numbers into a hat and pulling out a response. And no one's being challenged on the loss mitigation underwriting methodology. And I view it the same way you would view a dog or a fly issue. If you're going to go ahead and do a calculation where you're putting 15 data points in and you're getting a response, I want to see what calculation is being used. And banks across the board are saying it's trade secret, it's going to be an issue that's protected. But if you're doing a quantitative analysis on my client's finances, it's going to result in some kind of figure, calculation, or eligibility. Why are we not entitled to see what that is? So some banks have been agreeable to providing how they're going to use them and what program and what basis. But a lot will go ahead and defer to the fact that it's a trade secret. If you know how we evaluate these, that's going to be violating our own trade secret issues. So that's a real concern in that you have no check and balance to how they are going to use those numbers and use those things. And the bigger concern is that banks themselves have admitted that they are using documents and finances and loss mitigation for the purposes of screening post-judgment collection. They're data mining to see who they want to go after post-judgment. There was a recent, not a CLE, but a recent educational seminar by the Mortgage Bankers Association. It was called Dialing for Dollars. Dialing for Dollars, how to use loss mitigation techniques to screen for who you want to go ahead and collect afterwards. So you have them asking for these things in the context of we're going to settle a case with you and resolve a mortgage, but they're saying, who's got money out there to go after once we get judgment against somebody? So the whole issue of loss mitigation underwriting methodology is very concerning. Now the HEMP regulations have come in and have made them account for how they conducted certain calculations, how they got from A to B, and what the resulting conclusion was. And we get to police that issue now. There are appeals involved, there are consideration that is involved. But beforehand, it was really putting numbers into a hat. They would pick out a number, and you had no way to police that. You had no idea to say whether it's an appropriate or not appropriate number. So the underwriting methodology is concerned. Is a big concern. That is due to the voice issues, and otherwise, I'll go ahead and close it off there. If anyone's got any questions, I'd be happy to field them. Yes.
Could you please share some of the experiences you've had maybe with the unlicensed practice of law?
Yes. A lot of folks, in the context of mortgage rescue schemes, okay, a lot of folks who are, and we get tons of them on a monthly basis. I had some service that I retained, ABC, Defense, ABC Specialty, and they're based in another state. And they're not going to help us out with a lawsuit. But you have these third-party companies out there that are not attorneys, they're not based in Florida, what's licensed in Florida, and they're telling people that they're going to modify the loans for them. And they're making guarantees. I mean, you know, even with attorneys, we say we can't guarantee the outcome, but they're making guarantees as to outcomes. And they're giving legal advice as to what borrowers should do in the context of getting a lawsuit. And we're talking about pre-suit where they, you know, have an opportunity to get an attorney later. We're talking about in the middle of a lawsuit. And there have been, I've seen 6 or 7 companies that we see routinely that the client will say, well, I don't know why people wouldn't help me out now. I paid them all this money. And at the end of the day, it's clearly EPL. They're doing nothing but giving them bad advice and really doing nothing at all to earn their money. So it's a pervasive problem with regard to borrowers and foreclosure and default. And part of that problem too, again, comes back to the bank, the universal bank underwriting dictate that you've got to be in default for us to help you. So, you know, but for those comments, maybe they wouldn't go ahead and be in default. I don't know. So, any other questions? Yes?
I have a question. Isn't it a little tough to challenge standing when no matter who it is, the plaintiff walks in the courtroom door holding the original note in the hand?
Well, I would say, no, that alone is not going to win the day. They got to prove they held that note when they filed suit. Now,
right, I mean, when they walk in initially and they file suit, they've got the original note in their hand.
They don't do that. They go ahead and file a copy, and they'll file the original note later in time. But so often, the original copy has no stamp on it at all. It's a totally undated. Sure. And the other thing is to have conflicting instruments. Some of these cases we have both an assignment of mortgage and an endorsement. And one of the problems is if they're going to rely upon holder in due course, one of those predicates is delivery. If you've already assigned that mortgage to somebody else an assignment of mortgage, how can you deliver it? You can't deliver it. It's already been delivered. So you lose on holder in due course if you have another assignment of mortgage out there. And then you have these assignments of mortgage that purport to be retroactive. This is signed on January 10, 2013, but the transfer was August 10, 2011. No! I mean, you know, there was nothing to benchmark that happened back then. So you have these people trying to go ahead and go back in time and say, this is an assignment that we dated yesterday, but it really intends to be back for 2 years ago. So it's questionable there for sure. But yeah, the Jeff Ray and Progressive, all the case law and Siegel, all the cases talk about standing say you've got to have standing the day you walk in the door. You can't fix it later. Yes?
Touching on his question, I thought an administrative